Good morning, this is Gabriel Jackson, and welcome to BJC Mitzvah Day, number 58, part 5, a mitzvah that keeps us on its way. Yes, this is a long one. It might even take a part 6. The obligation upon Beis Din, the court, to judge cases of civil litigation, once again dedicated in the honor of our holy IDF soldiers. May they be successful in eradicating all the evil among them. May Hashem protect them, and may Hashem protect Klal Yisrael, the Jewish people. Here we go. The Chinuch now presents several laws pertaining to collecting a loan payment from a borrower's property. Also included in this mitzvah are the law that concerning all documents, the absence of a guarantee in a document is presumed to be an oversight of the scribe and not an indication that such a guarantee is not in force, with the exception of gift documents, where the absence of a guarantee indicates that the giver did not guarantee the gift. The law of one who attempts to create a lien on his movable property. The law concerning one who designates his field or his slave as an apotike. And that means, it's an acronym for apo, you the creditor will stand here. It refers to property specifically designated by a debtor for collection in case he is unable to pay his debt. Whether the debtor designated it as a non-restrictive apotike or a restrictive apotike. And the law regarding seizing the value of improvements in the land and produce of the land, as relates both to one who has been robbed and to a creditor who seeks to repossess land from one who has purchased it. Chinuch lists 2 laws pertaining to documents. Also included are the law concerning one who lost his document or whose document became erased, and the law concerning who pays for the writing of a document. The Chinuch lists another law relating to the seizure of a debtor's property. Included in this mitzvah is also the law that a property appraised and seized by the court for the creditor must be returned to the debtor at any time the debtor offers money as payment for his debt, unless the creditor subsequently sold, bequeathed, or granted the seized property as a gift to another. The Chinuch returns to the topic of oaths as well as general laws regarding litigation. Also included are the law regarding those matters that do not involve an oath, but rather a general imposition of excommunication. The law that we do not require one to take an oath based on the claims of a deaf-mute, a mentally deficient individual, or a minor, along with the various laws that arise from their unique status with respect to their interactions with fully functional adults. Included also is the law that we do not accept testimony unless it is presented in the presence of the litigant against whom the witnesses are testifying, and that the testimony presented against the litigant who is a minor, even in his presence, is the legal equivalent of testimony presented against one who is absent. Yet other issues included are the law that a blind person is legally equivalent to a person with sight in regard to all matters except with respect to the acceptability of his testimony, the laws regarding a merchant with his ledger, and the law that a mamad shlashtan transaction affects acquisition, and that such a transaction is a rabbinic law for which no rationale is necessary, as well as all that is involved in this topic of mamad shlashtan. So you say, what's that? So he says, literally presence of all 3. Transaction operates as follows. Reuven has in his possession funds that belong to Shimon, which Shimon wishes to transfer to Levi. In order to do so, Shimon need only verbally declare in the presence of all 3 parties that Reuven transfer the funds. The oral declaration uttered in the presence of all 3 parties suffices to transfer ownership of the funds without any formal act of acquisition. Wow! Very, very long. We will continue tomorrow. So much going on over here. We have to learn it really in detail with the commentary. But for now, you get the gist. We'll see you tomorrow. To sponsor, click the link below.